Yes.
Let me see. Well, I can remember for few months.
Contempt matter.
One thing, which time you granted, I'll reply you.
You were granted time to file the reply on the last petition.
Fine. No, either, earlier I have not received that copy. I have received the copy now. So,
He did not give you the copy on that day.
copy received.
On Mr. R.M. Chaudhary, Learned Counsel, appearing for the 41 of contempt is submitted for the sole respondent. Submits that he be granted 2 weeks time to file his affidavit in the matter. Course of prayer is not objected to by the Learned Counsel. Course of prayer accepted. Objected, prayer accepted. Registry to lift this matter immediately after 2 weeks from the day for here. In the meantime, the sole respondent shall bring on record the stand by way of filing and affidavit. Also, no further adjournment would be granted for filing affidavit by the respondent hearing. Also, the registry to list this matter again on after 2 weeks. Importantly, registry to list this matter again after 2 weeks, along with WPC number 5769. What did you say?
I'd like to mention item 19.
Master.
This is slide accommodation. Can you be taken in the next slide?
When?
Today, we're not going, I'm able Mr. Sharma in this case,
What is there?
Also, for headmastership.
Headmastership, he is a ME school teacher.
Right.
He was amalgamate.
Right.
He was a graduate teacher.
Right.
So in terms of the rules holding the field, he is entitled to
Right.
seniority. You are entitled to seniority from 2030.
Right.
And
Can you be taken up in the next slide?
a prayer is made on behalf of Mr. R.P. Sharma and senior counsel for an adjournment in the matter on account of person inconvenience. Prayer is not objected to by the learning counsel for the respondents. So accordingly, the registry to list this matter again after 2 weeks on a day 2 weeks.
All right. Make this. Item number 12. Although it's very urgent to us, but we need to clarify it. Can it be anytime next week?
No, this is only to refer it to the mediation cell.
No. We do not want a mediation because between the parties already sorted out. After the honorable court's judgments, the decision has been sorted out. How we approach on the authorities are not accepting.
That's why I'm
That's the
saying,
problem.
that's why I'm saying have a approach to the mediation. It may work out.
The mediation is not in between us.
No, it will be your parties are the government is also here a party. Then same thing. Have a try.
I was on the impression that the government did not come from mediation.
No, the government will also be called. Everybody will be called.
But the lawyer to represent in otherwise.
Yes, naturally, the normal mediation,
Otherwise they
the
can.
normal mediation process, whatever you follow. Right?
So may have to early basis.
We'll do that.
But I had stopped consenting otherwise.
No, you can inform them, come back to me when the matter is.
Take it tomorrow.
Then let the matter be called up. I'll keep it. You come back. Ask your junior to be with us.
But look, I get to information in the package. This matter was the order that will comply with it.
I take first one.
All right, complied with. Your name?
And
Mr. M. Dekar, Learned Counsel for the petitioners. On instruction submits that the directions of this court violation of which has been alleged in the present proceeding has since been complied with by the respondents. Also, the said position was reiterated by Ms. R.B. Bora, Learned Counsel for the appearing for the respondents. Also, in view of the above, the contempt petition stands closed and notices issued stand record. 36.
that is. A bigger one. Oh, I think you mentioned I think
20?
28, madam. I filed an additional application.
Additional affidavit for what?
Hello, sorry, hello, application get done.
Mr. B.K. Das, Learning Counsel for the petitioner submits that an additional reply on behalf of the petitioner was filed on
I'll not, not.
15/7/2025. Full stop. He submits that the matter be taken up along with the said additional reply so filed by the petitioner. Full stop. Accordingly, the registry is directed to discuss matters again after 2 weeks on the date to be fixed by, along with the reply stated to have been filed by the petitioner in the matter on 15/7/2025.
None of the, can be a lot earlier.
Today I was about to allow your repetition. On an adjournment taken. What is there?
No,
Nothing
I'm
is.
not taking adjournment matter. No,
Okay,
Malab,
fine. Let it come. You have filed something, let it come. We'll see.
Malab, taken up.
Order pass. 6/1 suspension, 90 days, no review.
Yes, madam.
Then
I have
you
only.
should have argued openly. Finish up the matter. Why
Yes,
take-
Lordship, kindly taken up.
No, not
Kindly
today.
taken up.
Now.
I'm not paying for adjournment matter.
Okay, you have filed a reply. We'll also have to bring it on record.
Malab, that's why I'm
That's
repeating
it. We'll have the record together after 2 weeks. You wait. These matters don't, these are technical matters. Why you have to have a pleading? No dispute on that.
Fine.
Then they have also admitted in their affidavit.
Fine.
Why? What was the necessity of you filing a reply? Okay, we'll see when it comes up next time. 1 week will be.
Regard to item number 30, okay?
30.
30, 30.
Ah,
I can inform that petitioner is by lordship. We will not.
so you will have to file a substitution. Okay. Let the matter reach because service is also complete here. I'll pass the consolidated order.
I'm-
When the matter. Huh?
I'm paying for.
Respond number, please. We'll pass the consolidated order. We'll grant you time. Don't worry. How much time would you want? Okay. Your name?
M. Nirola.
M?
M. Nirola. My name is. We have a.
Fine.
I got to mention item number 2 here also. So he is having some personal difficulty with your lordship. That can have to be listed up.
This is only to refer to the mediation. So nothing. I'm not deciding the issue. Only referring it to mediation. So you need not worry. Yes, Mr. Bose.
I can even it took an infraction. This is regarding the non-payment of media. Okay,
Okay.
all the.
Mr. A. Boro, Learned Counsel for the petitioner, submits on instruction that during the pendency of present proceeding, the issue involved herein has become infructuous. Accordingly, he prays that the petition be closed. Also, prayer is not objected to by the Learned Counsel for the response. Accordingly, the petition stands closed as having become infructuous. Okay. Item 1, disposed of. You will get the order by Monday or Tuesday. Need your name. Disposed of.
Thank you.
You argue. You argue. You argue. Your senior is not required. You argue. You get your. Ms. Musari, I'm remanding back the matter to the. DLC has considered. SLC has not considered. So SLC has to consider. Or you inform them the reason. That's all. Why keep this matter? Let her prepare. We'll. Hey, tomorrow to order mediation order. It took the law. Same. Your name?
Sharma on behalf
S. Sharma on behalf of
of
D. Chaudhary. And Madam
M. Burman on behalf of Mrs. Leland.
M. Bormon for the respondents on behalf of M. Bormon on behalf of
Mrs. A. Gandhi.
Mrs. A. Gayan for the respondents. Date to Diba. তাত কিমান তাৰিখ মানলৈ কৈছিলো 7 তাৰিখ মান গৈছিলো তুমি এইটো তুমি 11 পৰা আৰম্ভ কৰা হ'ব। 11 বাকী একেটাই ন? Yeah. Ms. Bora, appear before the mediation, sir. S. Bora, Learned Counsel for the petitioner. D. Mushahari, Learned Standing Counsel, Secondary Education Department. Ketu Koridia, Baba. No? Mr. Soikia, mediation. It'll go before the mediation, sir.
So,
It's a
basically, they have got the instructions. They have got
prior
the
before
instructions.
the,
My lord, my prayer is that, and I have yesterday, I have come to know that instruction they have brought Mr. Goswami, that there is no such thing event against this man. And the man is on the deathbed. He is 86 years old. And he could have directed to release the pension, and pension was released. But why the decision should be held up? They have given an undertaking
Okay.
before Honorable Justice Sapre at that
Hey,
time.
madam, what happened?
Mr. Goswami has got the my lord CID. Mr. Goswami, let us wait for 2 minutes, Mr. Goswami.
Guwahati.
Yes,
You.
but this
No, no.
cannot be held up, my lord.
Oh, sorry, yes, got it.
This cannot
Get
be held
Mr.
up,
Fukon also.
my lord.
Get Mr. Fukon. Fukon will have to pay. PJ Fukon.
And but the Mr. Goswami report, CID has got the report.
What is the report? What does it
Because
say?
there is no such thing. So,
So get both of them.
25 years.
Get both of them, we will consider.
Let the university pay the relief of the my lord. This-
Yes, why have you not released? Gratuity? On the way. Okay, we'll wait for it.
Yes.
Whenever he arrives, kindly let us know.
Let it dispose of my lord. Because the man is on the deathbed.
We will dispose it off with cost.
Instructions come.
We'll dispose it off with cost.
My lord, I am humble prayer before Lord.
I'm doing it.
My lord,
You get hold of it.
my lord.
We'll not keep Mr. R.C. Soikia waiting for a long time. If he does not come before I finish my admission matters, we are taking it up and disposing it. I think. This is, we have put it before the mediation cell. Just go there. Maybe it will be settled.
The last order, the instruction was.
List the matter after ensuing summer vacations.
Ordered it 6/6. Okay. 6/6. Okay. The instruction that's made by the leader. It was get.
No instructions. Mediation cell. That will dispose of it. Your name? Huh? T.K. Das. Our for the petitioner and Ms. D. Mushahari, Learned Counsel appearing for the respondents. For these respondents in the secondary division. Who is appearing for the director of Ms. K. Fukon and Learned Counsel appears for the government advocate appears for the director of section. Etu Koridia, 11-12 bolna. Etu to meet 13. The number of the coordinator, everything will be there in the order. You just contact and go. And ask your authorities also to be there, both of you. Mediation. Your senior is an expert in that. So let him also go and enjoy a mediation.
As per my instruction, mediation is not possible.
Why?
Because we are paying her pension as per her employer.
Okay, fine. Go and settle out there. You can, if it is failed, it comes back to us, we'll consider. But Mr. D. Bormon, Learned Counsel for the petitioner. Also heard Miss. Also her, who is appearing for the Shama, Learned Counsel prepares for the Standing Counsel, Elementary Education Department for respondent number 1 and 2. Mr. S. Bora for respondent number 5. Respondent number 5. 3, 4. Let's get for 3 and 4. Standing Council? Karbi Anglo. Who is for 3? Just write it down in a piece of paper, the respondents. Huh? A2 to me, India. 14. 14. Just write it down. Come on. Just write it down.
But here is the development.
Ah,
There are similarly persons who have filed a petition on 14th, there is a judgment, they will also, the date of second regularization, after the SIV, they will get the challenge. So in fact, therefore, you will not get the, they will come under new pensions, not the old pensions.
okay, go before the mediation cell. Have a mediation in the matter. Something positive may also come. Heard Mr. M. Sultan, on a council for the petition. Also heard Mr. S. Bora for BTC, Learned Standing Council, BTC, and Mr. Sharma, Learned Standing Council, Elementary, appearing for their respective respondents. Sir, it took 4 India. It took 4 India 18. Yes. Mr. Purkhaisto, we've done lot of cases here. Do some matter in mediation also.
Already areas part is
I have an
left.
instruction not.
Complied with.
So the proposal has been sent to the government for sanctioning.
Why it has not been sanctioned? Why? When was the proposal sent?
It was sent in fact on 15th of July.
Why so late?
So for both the MSCP as well as areas, lots of areas.
Only that part is still intact.
Now it will go to the finance department.
Lots.
Another 4-5 months. In the meantime, you come from the mediations. But Mr. B. Purkhaisto, Learned Council for the petition, also heard Mr. Sharma, Learned petition. Just write down the names. Respondents. Write them down. It took India 19th. No, 19th. 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 In the meantime, by the time they do it, it will come back. We'll see that. All of it. Mr. Bonik, we are giving you, giving it on 5th of August.
We would also file an IU. Even of the application, with on board, which says that my share of family pension, I'm without money. Although this was decided by this honorable court, the interim payment of money in it.
We will see. Just go there. Let them, on 5th, you take up the matter in the mediation cell.
Would it be prior to that fourth or
4th.
first? Because I literally pending it.
Okay, we'll have it on first.
First.
As Bonik, Learned Council for the petition. Also heard Mr. Islam, you are appearing for?
Respondent number 11.
Mr. M. Islam, Learned Council, Mr. A. Borua, also heard Mr. M. Islam from A. Borua, Learned Standing Council, ANPG, and Ms. M. Bhattaji, Learned Additional Senior Government Advocate, and appearing for their respective respondents. Appear on 1/8/2020. No, we have done it. 1/8/2020. Ms. Bhattaji, also ensure that your representatives, your authorities, representatives are also present, or an authority is given to you to represent before the mediations. We have put it on first.
So nothing, one is can be required to produce the record, my idea on to directed to produce the record.
For what?
And that is equipment,
Record?
record of equipment. Result of the
Why
equipment.
is the record required? 4 posts were there. 6 persons were appointed. SOP says that a compassionate ground appointee 5% can be done. So one is a compassionate appointee. Another one, he came through the review medical board because he got 66. Now, even if we interfere with that appointment, 66, neither of you are entitled because you have got in the House of 50s only. You don't have any caste reservation. And the other issues that are there, that has already been taken care of by the Meghalaya High Court pertaining to the same. Huh? OBC, but they are only 50, 51 or 52, something like that. The boy is 66. Maybe, but they don't come within the merit position.
You're waiting for the result. Because it's need to gain the license. I'm putting it on online.
Not satisfied.
You have to-
You see your marks. Page 88. You are, forget everything else. Come to page 88. Got page 88. This is your own document. You have brought it on record. You see the marks of Rajkumar in the top. A 6 OBC 63, right? And your respondents is in 89. First table, last 2 names. So, no ground for interference. And it is also now settled by the judgment of the Meghalaya High Court that 4 plus 2 was 3. What had happened in Punjab had happened in Punjab. That case was withdrawn without jurisdiction. Want to have certain further examination? Okay.
That's for the last order, Logic. They were directed to.
Yes.
Report without.
Yes, Ms. Musari, why her name was deleted? She is English. Your whole affidavit is on the basis of respond number 6.
Yes.
That is that alternative English. What is alternative English got to do with English? Why her name was deleted? You have not even remotely indicated.
Yes.
Get your instructions. We'll take it up after.
After Sunday.
I just want to know why her name was deleted.
Yes.
That's all. And you file affidavits, you don't deal with that main issue. Beating around the bush. Why? This is not
Paragraph 5, it is clearly recommended her name.
Oh, but why deleted? It's nowhere there.
No
So
way.
we can't presume.
Right.
Let her get her
Yes,
instructions.
yes.
Who is appearing for the respondents? PWD. Who is there for PWD? You're there. Get somebody. Get somebody. Mr. Bhattakur, here we only know about petition number 2 and 3. Review was, what about petition number 1?
He has given up there.
He has got no.
Review petition was filed by petition number 2 and 3.
2 and 3. But I passed the order. So only we'll say in view of these said developments, those 2 posts appoint them. Notionally from the date when the others were appointed, and they will be given their benefits from the date of appointment. Seniority and all will be counted. Disposed.
Deputy.
None appears for the petition on call. Business for the petition stand for non-prosecution. Ah, 17, you are there?
Yeah, sales.
2008.
In the year 2009, I
Eight.
approved-
Eight.
Yes, ma'am.
Ah.
My father died in the year
Ah.
2008.
Then
I applied for the-
forget it. From 2008 till today, you are living, sustaining.
Rejection ground is come.
What is the result?
Rejection ground is based on 24.
24. When was this rejection done? 11. When did you approach this court? Where is the reason for the delay? 10, 11 years, 12 years? Okay, where is the ground, where is your sufficient feelings on the ground of delay? Justifying the delay. Not there. Not there. That's all. If you can wait for 11 years, that means you have no requirement for a compensation. Pass whatever you like, but 2011, this order, where is the ground of the delay in approaching this court in 2022? No, dismiss. End shop. Over. That post will go to some boy, meritorious candidate in the village. Compassionate appointments cannot be spread so far. Reply? Here? What reply you want to file? You have already filed. Or if 15 to 24, today you want to file a reply, rejected. Alcohol syndrome. Huh? You say Guwahati Medical College has given you some certificate, right? This certificate is of 2017-18. Your rejection, your discharge invalidation is of 21. You have not brought on record in your appeal any medical document. Other than that was there before.
I was submitting my documents. Refused to accept the documents.
That is not your stand. In your writ petition, that is not your stand. Your stand is because of COVID, there was delay. Now you tell me, they rejected. They did not consider your appeal. Fine, I'm with you. But immediately thereafter, you were again admitted to Guwahati Medical College for nervous disorder. Ah, so that finding. Huh?
I think them to.
That is not for the armed forces. That is for your family to do.
They find.
Yes, madam. The finding of the medical board is supported by your subsequent hospitalization. Your subsequent hospitalization in 21, after your order of invalidation was passed, establishing that you continue to be an alcoholic dependent person. And such persons cannot be retained in the armed forces. Any other thing?
You can also see based on one, electoral one, based on three. The medical documents which I have submitted, issued by the Guwahati Medical College, I have improved from the.
Improvement does not mean, my lord, madam, that you have become fine. That shows that you were suffering from a psychotic disorder. And see, how can a person of this nature be allowed to remain in the force? He is using a gun. If he misuses it, you come to your come to page 30. Your invalidation was on 2/1/2021, right?
Hello.
Then page 30 is a document of April 2021. Same thing. So this document establishes that the findings that were there for arriving, materials that were there for arriving at the decision in January 2021 is proper.
Hello.
You want some time? Okay, done. But Miss so-and-so, oh, right. Prepare, I'm with you. Show me how. Otherwise, conduct is not very. This is a writ code. You will have to get me to exercise my discretion. Material should be there. Yes, Miss Sharma, you're very silent boy. Seems that you don't have a case.
No,
You have a case. But Miss also that Miss Sharma, body response. CGC. Parties have been heard at length over. Hearing remains inconclusive. Registered in this matter, it was spent. Give me a date. Auspicious date.
Okay.
No, you give me a date. You give. I'm giving you that. Again on 5/8/2025 as a part of Who is respond number 2?
ICAR. Otherwise, the dispute is between the petitioner.
Why are you coming in? Where is the university authority? Agriculture, Assam Agriculture University. They have not filed their affidavit.
That
Right.
is what I wanted to say. Also. We are not a party to the dispute.
Okay, you be there, your formal party, make your bills. Take your seat. Get your, where is Mr. Kyle? Get hold of Mr. Kyle. You have nothing to do here. Formal party. Enjoy the proceedings. No affidavit is required. Just tell me whether this post of deputy something is equivalent to.
He was engaged in the office of the, the commissioner, and
Deputy
additionally,
Chief Executive Officer and you are additional something, right?
yes. He
You are
posted-
additional assistant development.
Assistant Development.
Same,
Development
same.
Commissioner. No, madam. He was posted as additional development commissioner at the office of the commissioner. Additionally, he was engaged in that post.
So his
He is-
substantive
he is
post is-
paying, he is, the pay of the additional development commissioner. That
Can't
was
be.
additionally.
Now the proceeding against him has come to an end. One penalty is one increment or something. So how can you continue him as a deputy against that additional post, not against this substantive vacant post?
My lord, lordship may kindly.
Well,
allow
that
me
we
to
have been
file
giving
the
you
affidavit.
time.
Lordship, there are the listing of the.
We are giving you time from long.
Only 7 days. I am undertaking, my lord. I will file.
I don't want your affidavit. I only want that instruction. Why?
My lord,
How?
that instruction I have already prepared.
Why and how? Just tell me today I am disposing of him. Why and how?
So, can I please?
So you agree that his substantive post is assistant development?
And he was posted. Reply to 15, 16 and 17. That.
We have no dispute with his conduct. He can be allowed to hold the charge of any post. But what is his substantive post?
ADC.
Where?
Well, in the office of the commissioner,
Where is that order? Posting him as ADC.
my lord, he already joined there.
He joined there, then he
But I-
modified it.
My instruction is saying so, my lord, I'll put it the document.
Have you been given a posting as a ADC? On the prayer of the Land Council 40 parties, raised it to the book matter after 2 weeks on a day.
Hello.
Read your briefs, Mr. Council, read your briefs when you come. Right? We read, so we spend time. You also spend some time. There is no fun in taking an adjournment. Ms. S. Baru, Learned CGC, submits that affidavit on behalf of the respondents represented by her is ready and would be filed within a period of 2 weeks. 2 weeks from today. So accordingly, raised to this matter after 2 weeks on a date. Or after 4 weeks on a date to be fixed by. In the meanwhile, the petitioner is also at liberty to file a rejoinder to the affidavit so filed by the respondents, ipso. This ground is not accepted.
Yes, Lordship, but allow us some time, Lordship, so that we can inquire whether the
Time till 2 o'clock.
Lordship,
Then SLC has approved his case. 2023. Your decision is of 2024. You are now taking it back to
it has
2023.
been, days before the finance department, Lordship.
Can't
so
help
they
it.
have listened.
They-
Now
they
they
can-
again have given us, the finance department given to
Is
personal
finance department a party here? Who is it?
Then
Yes, Mr. Morpujari, what is this? Recommendation made. It has attained finality in terms of that decisions of this court. Appointment has to be given now. Now, a year gap takes place, you come with a decision abolishing the DLC, SLC, everything. Here it's of no use, it's not, got no application here. Because the decision has already been arrived. Then, this is not a matter of policy. Abolishing the SLC and DLC will have got no effect here. Because his case was already transferred to that body.
I cannot put the fire retrospectively. Okay, but then that whether pending with the personal department as well, I can take it into discussion.
Who is 40%?
Lordship, I am appearing because this was placed before the finance department, then the finance
This
department.
is just
Yes, Lordship,
passing
just
the buck, delaying.
kindly a second, Lordship, here with me, Lordship. Lordship, then they have suggested to obtain fields of the personal department first. Then this was resubmitted the proposal and this matter is referred to the personal department right endorsement dated 30/11/24, Lordship. So thereafter, personal department has offered their view and also advised to consult the matter with the judicial department. It is lying with the judicial department, Lordship. As soon as it is received from the judicial department, this will again be placed before the
Why
finance
we'll
department.
pass the
for
order
resolve.
today. We'll pass
this-
holding that he is entitled.
Then
That
Lordship,
is-
at 2 o'clock, I'll just obtain instruction whether judicial department has given any view or not.
I find it for the fact that the matter is.
In one of the cases, I have already passed them.
But whether
You cannot. You cannot. 18-9 is, I think, the decision. And their SLC is 2023 September. SLC?
March 2020.
March 2023, and yours, Mr. Doctor?
SLC is one.
Yes, on March 24, Lordship.
24. So, on that date, their rights have already crystallized. You should proceed and appoint them. Because that subsequent policy decision cannot be made applicable. No, that's it. So when are you doing the remedial action? We'll have it on Wednesday. As prayed for by Ms. MS M. Bhattaji, Learned Counsel, Learned Additional Senior Government Advocate, and Mr. R. Bhattacharya, Learned Standing Counsel, Finance Department, raised it to list this matter again on 23, right? 23/7/2025. So on the next date of listing, the Learned Stand Council's appearing for the response shall apprise this court as to why the decision of the state level committee in case of the petitioner's hearing have not been taken to its logical conclusion, although such decision was so rendered before the dissolution of the state level committee, which had occasion in the month of September 2024.
Lordship, reason is stated in our affidavit, Lordship. We have submitted on, this is it, because we have just for approval only, because the financial, these things has to be taken.
What I have
That's
said.
That's why we have,
That is why I have said,
yes, Lord.
the policy
They-
decision,
they-
policy decision to abolish came in 2024 only.
It's 24 September,
September.
September 24, and it
So,
was before that.
Both of
one.
you, I have said,
Yes.
I've not only said you, I've said him also.
Yes.
Both of you get that copy. And there is an order already. I think I have passed an order in one of the petitions. I think it's annexed here, yes. 5239/2024, page 35 in Montu Bayan's case. I've clearly said, I've only refrained myself from disposing of that. Take. Same. So now that you are here, you do the rest, use your good office to help them out. Because compassionate appointment, otherwise I'm, when there is a delay, I'm not very sanguine to come in. But here, the matter was taken to its logical conclusion. As far as the consideration part is, ministerial act, how can you deal? Subsequently, it's just a ministerial act. But-
But the petitioner was considered as 31/24. Immediate petitioner, period of 90 days, no review, and then supposed to.
Inquiry is also over. They were supposed to. Yes, what is the order passed? Order is by the revenue department. Yes, what is the order passed? Mr. Bhattacharya, you were
Yes, yes.
supposed to place the disciplinary
Yes,
authorities
yes.
order. Any order passed?
No, but it is under consideration, my.
Why?
Before we have obligation, unless you family come to face the petition of your LHFC of their. That's another thing for
37.
Cannot be complained by them. But you know, the situation of they like you. They can get. It's under consideration. You have received it from the dealer, you know.
He was given a notice after the inquiry report in March, April. And when did you submit your reply?
Presumably there are some others, but I definitely to the penalty that let's see.
That is for you to challenge.
Whenever it comes. And Lordship, it was also one, there is a direct signal that we can actually say. Where we might wait for the conclusion of the development. Now that my expectations are disagree, and now that since FIR matter that we are considering it.
No, you were considering as on 25/6/2025, it was undertaken before this court, before me. That fix it sometime today, so that on that day we will place the record. We will place the order.
What is the timing of the para 11 of the court? Same argument was made because the date. Para 11. Very different.
No dispute. No dispute, Mr. Patwari, no dispute.
More than what I'm happy has passed.
Yes,
I have to take to the submitting matter, my colleague, as that way to looking after this matter.
go ahead.
But the procedure is to fix this matter at today or my day after tomorrow, my kindly. Okay. And so. Yes. Yeah, it's paying for reinstatement of the you suspended on matter. Then.
Yes, Mr. Goswami, what do you have to say here? Date of suspension?
On my lord, 7/9/2024. Effective from 10/9/2024.
Page?
My lord. Page 46.
46.
46.
This is 6-1.
My lord.
No criminal case involved here.
No.
Then what happened?
Then my lord, effective from my lord 10 September 2026, 48 years.
Page 48.
Page 48. Effective from 10 September 2026. And then purpose from 23rd September 2026.
Show cause is 49.
49.
Then where is the order extending the suspension order? No, no order was passed.
Order is that place, my lord, in their affidavit of the internal page 119, 119, annexes the law. It was reviewed on 29/3/2025. That's the left of the 6 mark.
20.
9/3/2025. Page 119.
This is the first review meeting.
My lord.
Yes, Mr. Goswami.
Second review, after that, Lordship in 113.
Forget it. You issued the show cause on 23/9/2020. Where is the order accompanying that show cause? Order of review of the suspension accompanying the show cause in terms of para 20.
Lordship, it's okay, but it's Also, the review was done also after the 10/3/2018.
Review was done on,
10/3/2018.
where do you get that?
Yes, it is 113, page number 113. Internet page 3 of my affidavit.
Okay. With your this statement itself, the suspension order does not survive after 23/9/20.
So opposed was submitted. So opposed.
Show cause requires to order to accompany, para 21 second line. Ajay Chotan.
Look, but after issuing the jersey clothes, the orders.
I'll record your submission. If that is your understanding, we can't help it.
Lordship, on that ground, Lordship, I think.
No, today.
Lordship, at two.
At two. Yeah, interfering with.
Yes. Other than I have also, I will work with that.
Which one?
Respect of Mega. Neither case, my Devanta Polita.
Huh?
Devanta Polita.
Diganta Kulta, I want that. I want that one. It's a Patwari book.
Another two, you can transfer also.
You. Non-appeals for the petitioner. It is seen from the orders passed by the Laojima Court. Ms. M. Bhattacharjee, additional senior government advocate is present for the response. It is seen from the orders passed by the Laojima Court, the petitioner was granted repeated opportunities to take steps for service of notice upon the fresh steps for service of notice upon the response number 5 to 7. However, the petitioner failed to comply with the same. So, in view of the above position and the non-appearance of the learned counsel for the petitioner on the on today, the present petition stands dismissal for non-profit.
15.
But Ms. M. Nirola, learned counsel for the petition. And also Mr. S.S. Lloyd, learned counsel appearing for the response number 3 and 2. Also, Ms. Nirola submits that during the pendency of the present petition, the petition has passed away on. Has passed away. Also, and accordingly, it submits that she be granted 3 weeks time to file an interlocutory application for substitution of the petitioner by his legal rights. Prayer accepted, raised to this matter again after filing of the interlocutory application by the petitioner. By the of the said interlocutory. Okay. Yes, we would have Mr. Bhuyan. Yes, Mr. Bhuyan. Okay,
Find the file.
Oh, fine.
Where is it? I have.
Where is the earlier order of this book?
Order does it, 3rd January 25, every kind of signal. What does what say?
No, the earlier order passed by this court,
Problem before.
page 10. Can you take this stand now, Mr. Tapanyan?
You have not taken that stand.
Mr. How can you take this stand when there is already an order of this court? This stand was never taken before this court earlier.
Yes, I have seen the, what was the last one?
If they have not resorted to a departmental proceeding, it's their discretion. How can you force them to take an action? Is it a law that if you are not there for 5 years, automatically the service goes take up? Well, they have regularized, maybe they were satisfied. How can you question them? And the director had come to a conclusion that there is a necessity to retain her services. So how can the finance department question the wisdom of the education department in taking a decision? They are not paying her salaries for that people. Then Mr. M. Bhuyan, Learned Counsel, as requested by this court, Mr. M. Bhuyan, Learned Standing Counsel, Finance Department has placed before this court the instructions received by him. A perusal of the said instructions would go to reveal that the respondent, the Finance Department, is questioning the wisdom of the authorities of the Education Department in so, however, he submits that he would receive further instructions from the respondent, from the Finance Department on the matter and apprise this court of the same on the next date of this. Accordingly, raise it to this matter again on, give you 10 days time. 16, on 28/7/20, 29/7/20, you may have to hear this. Yeah, you can take it right. Well, you're working now,
Yes, ma'am.
getting your salaries, no?
Oh, they did not release. They are calling me and attending their occasion. But they are telling that wait. Inspector officer, director.
We'll finish it off.
They are, this very working continuously and for Hindi subject, good number of students have come out successful.
Look, we'll see.
Your own authority.
Absolutely.
Now they cannot take it.
Let us give Mr. Puyan, let him use his good office. Mr. Puyan, right. And Mr. Katonia, if some further instructions is to be given, material is to be given to the Education Department, kindly ask your respondents to do it in the link so that they can take a final. Because there is a line in the between. You can show him that noting, there is a line asking you to give clarification. You submit your clarification. You know? Mr. Das, just 5 minutes. Mr. Fukan, why is the gratuity kept withheld?
So that CID case was pending, my lord.
CID case is pending will also automatically lead to withholding of the gratuity. Or your charge sheet is,
My lord, kindly turn to page 23, earlier order. Page 23. Focus on the Kolita versus both others. Judgment rendered on 7/1/2013. The next page, my lord. Page 24, last two lines.
because the criminal proceeding would stand initiated
Yeah.
on the date when the police report is taken cognizance. Police report here is 173. CRPC, that is the charge sheet.
My lord.
Charge sheet is not filed.
Not given, my lord. My friend,
How can you?
possibly not.
My lord, we are not aware about that. My lord.
Yes. Mr. Goswami, charge sheet filed.
Lordship, by lordship. So for my instruction during investigation, sufficient evidence was not found against the petitioner.
Final report given. Then, Mr. Pukan, both ways you have illegally retained this amount.
In view of this. You have done. So, still get the time to.
So he is acquitted from all the charges.
Apart from.
So we'll have to give him some interest on that.
We were not aware.
It was done on,
Can you come to the RTA?
this was done in 24, 30/12/24, the impugned order is there. The order of the,
The petitioner has not intimated about that. We are not aware of that. So, Lord, an RTA application has been filed, but the RTA 18 has not been filed. The last two days. That honors release the petitioner also. Last 2-3 pages. The RTA annexure 9 and 10. Twenty-two. The petitioner.
Mr. Soikia, here the only grievance is with regard to non-payment of gratuity. We'll direct them to release.
On the price, without, they should pay the interest of.
No, they'll not. They'll not pay the interest.
But they will.
They will not pay the interest because in the earlier round of litigation, Mr. Pukan is correct.
No.
There is a direction from this court. You have not challenged that. Come to page 24, last two lines. It may be a erroneous order, but that order stands to
Yes.
relating the innocent shall consider as soon as the
Question to.
criminal proceedings are over. Criminal proceeding is over only on 30/12/2020. And you have not informed the authorities of that.
So, contact, regarding this, CID case, we do not know.
Mr. Soikia, the CID case was taken up by the, what do you call that, by the trial court. And your advocate was also there. There is an order passed.
Oh, that's when they release the,
But Mr. Assis Soikia, Learned Counsel for Balancing Counsel, Assistant Prime Minister, M. Sharma, Learned Counsel for the petition. Also heard Mr. J.K. Goswami, Learned Additional Senior Government Advocate, Hearing Party. Respondents number 1, 2, 3, 4, 5. 1, 2, 3, 4, and 5. And also Mr. P.J. Pukan, Learned Standing Counsel to Guwahati University, Hearing Party. Respondents number 6, 7, and 8. The petitioner, by way of instituting the present proceeding, has raised the grievance with regard to the inaction on the part of the respondent authorities in not releasing to him his due gratuity, the amount due to him under the head gratuity pursuant to his retirement from the services of the Guwahati University. When did you retire? 31/12/2008. Also, it is to be seen, the materials brought on record reveal that the petitioner raising similar demands had approached them earlier by way of filing a petition being WPC number 5456/2012. Also, the coordinate bench of this court, while order dated 7/1/2013, had disposed of the said writ petition with the following observations and directions. Page 24. APA. Also, Mr. P.J. Puttam, Planet Council for the respondent submits that the pension and other pensionary benefits of the petitioner were released to him. However, in view of the direction passed by this court that the gratuity amount would be so payable only after conclusion of the criminal proceedings initiated against the petitioner, the university authorities were not in a position to pay the same. Also, Mr. J.K. Goswami on instructions has submitted that the criminal proceedings initiated against the petition had resulted in submission of a had not unearthed any evidence against the petition. Accordingly, the charge sheet in the matter was not submitted in respect of the petitioner hearing. Also, further, in view of the result of the investigation so carried out, the learned trial court, while judgment and order dated 13/12/2022, passed in GR case number 777/2000, proceeded to accuse the petitioner and other accused persons from the charges so leveled against them. Full stop. How come if there was a no charge, no element, how come this?
The petitioner has not sent for trial.
Okay, to continue. So, Mr. J.K. Goswami on instructions are submitted that on conclusion of the investigation in the criminal proceeding instituted against the petitioner hearing, no material was found, no incriminating material was found against him, and accordingly, in the charge sheet so filed, his name was not so included as an accused person. Full stop. They said submission made by Mr. J.K. Goswami would go to reveal that the criminal proceedings instituted against the petitioner closed at least with effect from 14/5/2008, when the charge sheet in the matter was when the charge sheet in the matter was so filed before the trial court by the investigating agency, and the need of the petitioner was not included therein as an accused person. Full stop. The above discussion would go to show that the criminal proceedings instituted against the petitioner stood closed, at least should close as on 14/5/2008, when the charge sheet in the matter was so filed. Also, accordingly, the petitioner was entitled to his gratuity at least on a date after 14/5/2008. However, the same was not released to the petitioner. So, from 2008, he is entitled. You have not released to him.
Since 2013 order is here. 2013 order is here, and he has no pay, it's only 2012. And he is well aware about the entire except.
Also, in view of the set position, as well as the directions passed by the coordinate bench of this court, while order dated 7/1/2013 in WPC number 5456/2012. This court is of the considered view that a direction is called upon to be issued to the Guwahati University authorities to release to the petitioner his gratuity amount within a period of 1 month from the date of receipt of a certified copy of this order. So, Mr. R.C. Soikia, the counsel for the petitioner, has submitted that the petitioner, in view of the delay occasioning in release of to him his then gratuity amount, would be entitled to an interest thereon. Also, however, Mr. Soikia has failed to address this court as to the directions passed by this court while the order dated by the coordinate bench of this court while the order dated 7/1/2013 in WPC number 5456/2012 and further as regards the steps taken by the petitioner to apprise the Guwahati University authorities about the fact that he was not arraigned as accused in the charge sheet by the investigating agency in the criminal proceedings instituted against the petitioner here. Also, in view of the above position, the petitioner, if the court is of the considered view that the petitioner is not entitled to any interest in the matter, however, in terms of the directions passed herein above, the petitioner shall be released his due gratuity amount within the time frame already prescribed, within the time frame so mandated by this court herein above. Also, with the above observations and directions, the present petition stands in this course.
Lots of love.
Mr. Fukan is right, because
Here, will you put the whole one?
And
I would have loved if I had also added an interest, but because of your default, your means your petitioner's default, he is not entitled. Because you have not informed him.
And in 2022, RTI petition has been filed. Then he has been informed.
You know,
But that will not,
Okay.
no RTI has been filed.
our CID has told that they cannot give the.
It is okay, Mr. Sagar. It is only the question of interest.
It is enough, I'm highly obliged to. But this man has got the relief in the long run. Most of it.
Thank you. Okay, Lozima, come to the merit. Mr. Deka is appearing. For a petitioner. Petition, very good.
Told that the governing body on the principal, they are yet to file their affidavit in the review.
Anybody
And that is
appearing
required.
for the, anybody appearing?
Yes.
Who?
Mr. M. Smith, his junior was here.
Mr. Barbara,
Yes. So,
tell me that plea that you have taken in the review petition
yes,
was available with you on the date when the matter, when the writ petition was heard. You never placed this matter for this court.
okay, we kindly appreciate, one aspect of the matter.
That second letter that you have given,
19.
and second letter
Yes,
withdrawing. First was a letter giving that
14th.
I'm not entitled, I'm not inclined.
yes.
Then again on 19th, you gave a letter
Correct.
saying that this is not there, consider my case. This 19th letter was never brought to the notice of this court. This was a fact which was within your knowledge.
Yes. The important fact, another important fact is that, which I am urging before your lordship, that the vacancy surfaced in the month of
31/12/24.
Yes, 4 months prior, I can appreciate one situation that the promotion was given to me. And I want to forego the promotion, let the next one come. What is this practice?
But what is this practice? Its practice is you.
It's not, no, not the practice. Document can be appreciated. Prior to, 4 months prior to surfacing of the vacancy, an NOC was obtained. And I have leveled serious allegation against the erstwhile principal. 14(6). Thereafter on 19(6), I submitted a representation saying that consider my case for promotion to that particular court. That was never considered. It was nowhere in the records, neither before your lordships or before the GB.
Why did you not point it out to us?
It was not with me also.
Why?
Look, it's a part of the record.
Mr. Counsel, Mr. Das, when you were arguing the matter,
Yes.
it was within your knowledge that I had submitted an application on 19.
It was in the writ petition, if I am not mistaken, this 19(6) was there. But there was no.
Show me. Let's see the repetition.
Yes.
19.
But there was no endorsement of the principal.
So, how can we take it on face value now?
Lordship will consult the record. Because this is a serious, this has got serious bearing. If I have voluntarily given my thing on 14(6), why would I on 19(6) make a representation, say that you consider my case for promotion? Page 35. But there was no endorsement in it. I got it later on. There was a receipt by the principal in the review petition that I have annexed. Page 43 of the review. Why you did not act upon this?
I got it. Now come to the corresponding pleading at page 10, para 5.
Pleadings I understand, Milo. Pleadings I understand.
You
But-
you have never said that you have given, you just annexed some other
True.
things you have said, you have annexed the letter.
It was not,
What is that letter? From where does it germinate?
it was there in the.
There is no pleading, Mr. Das.
In the writ petition.
Huh?
True, Milo. It was not explicitly said, but
No, not even implicitly.
no, not.
There is no reference to that letter. You come to para 10.
Yes, no. Lordship will.
Para 5,
One
page
second.
10.
The petitioner that stated her harassment comments from, she wrote to the respondent number 7 seeking promotion to the post of senior assistant and was told that library staff were not to be promoted in the rank of administrative staff. When the petitioner to read the job, tried to reason with the reason principal and even showed him the rules of 2010 regarding promotion of the staff at the provincialized college, then the respondent number 7 principal became abusive and negotiated the petition. We stated hearing that the harassment continues in 2020 when the state person retired and not only the petitioner but several teacher staff so and so has been intimated and released and harassed by the state 2020. Type copy of the letter. But this letter was submitted by her. There is
By
no-
her, but where is that statement? That this was submitted, this was received by the,
Understand?
Can't
Miller,
help it now.
No, exhaustive.
this is a fit case for appeal.
no, exhaustive pleadings were not there. I
Not
can-
even exhaustive, not even indication.
Even then, the letter was there.
Letter, okay. Now let us see the letter.
Yes, my lord. Lordship will
Come
kindly
to page
appreciate one thing.
33.
No, Lordship will kindly.
Come to page 33.
Yes.
This is the letter giving up.
No, this is- Yeah, correct.
Giving up. It's in vernacular.
Yes.
Now why immediately a shift in English? At page 35.
Yes. That too, I also asked myself.
Here the
Why-
signature
why-
is also in Asmus.
Yes,
Here it is, Rita Bepari, Bepi. This gives rise to the doubt.
First one is an attorney, second one is a witness. But the fact remains that on 19/2016, this lady submitted an application because background facts of harassment were already there, those facts were feeded. But
If there was harassment, why did she not take steps? Either under the POSH Act or under before the police. or even a letter
I'm
to
not,
the GB.
I'm not asking your lordships to go to that extent.
No, I'm only examining that to understand the plea taken by you, that there was harassment.
Your lordship will kindly appreciate the, my plea from three facts, my lord. First, the vacancy surfaced, this is extremely important, my lord. The vacancy surfaced in the month of December. Now, 4 months prior to that, you obtain a, look, is it conceivable, my lord? Lordship has seen many cases of foregoing of promotion. When it is foregone, a promotion is granted. The person
When
says,
was
no,
the respondent promoted? It was promoted sometime in 21/5.
21/5/2015, and on 25/5/2015 itself, a proposal was moved by the principal for my promotion against the next vacancy. I'll place the fact before your lordships in C18, then your lordship will appreciate how the things are done.
No,
Lordship
we
will
will not give you a rehearing.
No, I'll not try to give I'll not
What is the error?
No, the error apparent on the page of the record is there. The vacant, if your lordships kindly come to page one, lordship will kindly mark one date, 16/10/2014. That was the date when the vacancy surveyed,
First or second vacancy?
first vacancy. Then 4 months prior to that, on 14/6/2014, this letter was obtained from me. Then 19/6/14, I submitted my representation saying that kindly promote me to the post, that particular post.
But you don't say there, one thing you have missed out, that the letter that I have given,
Yes.
that is withdrawn.
Yes, do well.
That is
No.
withdrawn. That is not there.
Lordship will have to appreciate the facts in totality, Milord. He was repeatedly saying in the petition that the principal exerted pressure upon her. Milord, those facts were there. Now, on 19/11/2014, the proceedings of the GB started, page 44. Here they refer the letter of 14/6 to be 16/6. Milord, dates are jumbled up. The letter is dated 14/6, now GB says it's 16/6. Then, my lord, on 31/12/2014, the second
When
vacancy
were you subsequently promoted?
to the post of
Senior.
senior assistant, I was promoted on 10/6/2015. The vacancy surfaced in the subsequent vacancy surfaced on 31/12/2014, same year. But you will
And
kindly
the
appreciate.
vacancy against which the other person was promoted, that arose when?
16/10/2014,
First vacancy.
first vacancy. Second vacancy surfaced 31/12/2014. They did not do anything.
Okay, let us look at this in this angle.
Yes.
16/10, when the vacancy arose, there was a letter from you on 14/6 that I don't want to be considered. Consider me for the second. Your subsequent letter is also with regard to the second vacancy.
19/6.
19/6.
19/6 was not with regard to second vacancy.
It is,
It was with regard to first vacancy because second vacancy did not surface that.
okay. So first vacancy, because we are not very sanguine about your that 19/6.
It's there in the record.
We don't know. We'll not.
Yes, fine,
We'll
fine,
not.
fine.
So the first vacancy, he got it. Even if we say that he was considered against the first vacancy,
Oh, but there, lots of things are done very cleverly. Lots will kindly.
they could have done an amalgamated selection.
Exactly. They want to show, and your lordship will see the day vacancy surfaced on 31/12, it was kept pending till May. On 21/5.
But the 16/10 vacancy was also kept pending till May.
Exactly. So on 21/5/2015, The private respondent was given promotion by a separate, separate DB, separate, everything was done separately. So 21/5/2015, he was given promotion. As
Who is holding the post of head assistant now?
No, Milord,
As per
there was
my
a recommendation in my favor.
Review petition is.
Review petition. How?
As per my instruction.
No, I don't have any instruction who is working as of now as head assistant because
These
recommendation was.
instructions you will not have it. Okay, we'll hear it. But Mr. H.K. Das, Learning Council for the petitioner, and also Mr. R.M. Dekar, Learning Council appearing for the respondent number 1, huh?
Yes.
Awesome. Total, huh? 288. No,
The respondent number
Raised.
6
6. Respondent number
in review 87.
87. Respondent number 1 in 88 and respondent number 6 in 87. Huh? Awesome. The registry to discuss matters again. On 21/8/2025. What's up? An endeavor would be made to dispose of the matter on the next day of this week. Accordingly, the respondents are liberty to bring on record their pleadings if any in the meanwhile.
Also will also call for the record for the.
First satisfied, then I.
Yes, yes.
And regarding supplementary post, page 36 of the petition record filed by her, 2472 of 2022. This is her representation, he clearly written that, now sir, at present, as per verbal order of principal KRB college, I am taking the responsibility of head assistant after retirement of former duty.
Can you see, except 21, either 19 or 26?
26.
Thank you.
26.
Take care.
Deeply.
Yes, Mr. Sharma complied with.
I have raised one instruction minus here.
Instruction to
On
effect.
examination of the matter, some misfacts as they arise minus here. And moreover, my lord, during the hearing process, it has come to the light that Vijay Sharma has not been service during the period of 7/9/2020.
Mr. Sharma.
Yes.
This is contempt. We will not accept this thing. Is the order being challenged?
Sometime maybe get.
Time means I can grant you time till 2 o'clock to comply. So 1 days, I can give you 2 days. Mr. U. Sharma, Learning Council for the respondent number 2, submits that he be granted further. That the respondents be granted further 2 weeks' time to comply with the directions passed by this court by the order dated 27/6/2024 in review petition number 106. Prayer accepted, raised it to list this matters again on argument on the on 31/7/2025, on which date the compliance report shall be placed before this court by Mr. U. Sharma. So, yes.
So even therefore
1/12, you know. In the meantime, anything that is to be done legally to set aside this order, you are liberty to take. Otherwise, comply. Thank you. Yes, what happened? Where is the government? BTC.
Where everything is.
When will you get the instruction? This is contempt. You are not at liberty.
1 week.
No. Why? Last location also same thing. 1 week time.
I not in seek we filed there.
Huh?
Filed the local account.
Who?
We explain on behalf of.
Mr. Rabha was appearing.
Yeah, yes, ma'am. So
Then-
on that day only we find that.
Oh, fine. 6 you file.
Yes, my lord.
Where is the law that, where is the law that after filing of affidavit, Wakalatnama, I have to give you 1 week, 1 month time?
One time may be allowed. We file affidavit.
No, we don't want any affidavit. We want the compliance report. Have you filed an appeal against that order? Have you filed an appeal against that order? Have you filed any review? Then,
I just come is communication,
you communicate clearly. We are having this on Thursday next. I want the compliance of, or we'll have your people here. This proposal has already been placed before the BTC authority. Why are you not taking a call on that?
as soon as possible, you will have.
As soon as possible, 2 o'clock. Get your instruction right. Right. Two questions before you start. Amendment is as per the schedule. The documents that are there would also form a part of the amendment. Huh? Where is the marking of the documents in the body? Come to the schedule. Where have you marked the documents? Annexes. You have just annexed that in your IA. But now it will go into the writ petition as annexure what? Right? Withdraw it, file afresh. On the prayer of Ms. L. Vajita, learned counsel for the petition. Ms. L. Vajita, learned counsel for the applicant submit that she be permitted to withdraw the present interlocutory application with liberty to refile the same, if so advised. Purpose of prayer accepted. Purpose of prayer is not objected to by Mr. R. Learned Additional Senior Government Advocate, appearing for the response. Accordingly, the present interlocutory application stands dismissed on the with liberty as well. You will have to say that this paragraph, along with this annexing, numbers so and put it in the body, not in a schedule, so that your verification is also. Okay. Yes. Mr. Thor, he is a compassionate appointee.
No.
Yes. Yes.
Brother of the competitor.
Mhm.
Pilot,
Durlop, brother is Durlop.
pilot,
Durlop was given the order. Then it was substituted by the petitioner. And again, a grade 4 post. You appoint him in a work charge. Fine, no problem. He is getting the salary. But he is a compassionate appointment. He should be within the strength of the service.
but pilot, if we go by the order of the appointment, there is nowhere it is in his order appointment. It's mentioned the reason for present appointment.
Why should be there? You come to the earlier orders. You don't act, your executive engineer, chief engineer is not acting on his own. He's acting on the directions of the government. Come, I'll show you. Come to page 16 first. Durlop Talukdar, brother. Then come to 18.
Exactly. He's
You come to 18, Mr. Dhor. First, come to 18.
18.
Come to the second paragraph.
Fine.
In grade 4 post on compassionate grounds. Come back to 16. Is approved in a grade 4 post on compassionate grounds, right? Then you come to 20, further direction. And the final order. Page 22. You put him in a work charge establishment. Why? There was an order passed by me in this connection. Yes, what do you have to say now?
How will then by this order by? He was appointed to both church category by
How can you?
93, my lord.
5% quota
My lord.
cannot be counted in the work charge. It has to be in the regular establishment. Or show me the law that 5% can also be counted in the work charge. क्या हुआ इसको?
I will find that. Today, it's no ballot in 19,625 ballot. I have. Let me bring that on. Give it done. Instruction is that ballot. Since you are counted ballot, you may voucher of yes. My lord, then there, my lord, then this order has to be well challenged, then it's set aside. Unless, my lord, what is my lord? But we don't keep up. My lord, we are on that, my lord. From 1993, he has been in what church, and he was not regularized. I look, our changes. Only there were minor years of regular. We are not saying regular. What? That. Oh, let's come up. Our affidavit. Next item, the number 39. I was so next item. Just like this, some time. In I, the chief told that with regard to the disbursement promotion, some more time in practice. Function of given yes, sir. Governments are yet to file the affidavit.
I'm for the English, I'm praying for 10 days time, and we have received instructions.
Right. Okay.
I think I got, I think I don't, wait a minute. No, wait a minute.
Said, for Andhana Police Ayala. So there were two appointments that we were. There was an inquiry, a hearing was conducted, and it has ended. Those appointment letters were state for which Gitanjali Devi is, she was not considered. Because Anjana Kolligan has given two appointment letters for alternate English and also for English. Yeah. Yes, your lordship. Lordship will give me some time overstand. Lordship, now they are saying that they will consider Gitanjali Devi police license. Because, yes, your lordship. Now they are not being very clear on that. So like, okay, now finance. For what step? Second.
No, already on customer base. You don't need to take one. Yeah, but I have already. But you can't.
How long will this go on?
Yeah.
Huh? That we have already, uh, 1 month, more than 1 month. No, disposal will be in this page. No, you do whatever you want to do. In the meantime, the suspension cannot. That would be a case at the initial stage. Now today, we cannot. I can do one thing. I can give you 1 week time. 10 days time, not more than that. This does not show you in good color. Such a serious matter, bribe case, and you are sitting over it. What happened to the criminal proceeding? Investigation. Then why should we suffer? Put in wherever you want.
I don't know that.
You're getting your subsistence allowance. Three weeks time. Huh? Was already given. That will do. That?
51.
Cannot give you time, 15 days time, of the order, backwards.
Till then pending.
Till then, restriction will be. Otherwise, if we pass this order, he'll have to come back on contempt. Same.
The moment the 90 days time is over without any review or assessment, The interim person, he is to active, he is not in charge. Never mind that no review matters. He is it.
Okay. Heard Mr. J. Patwari, London Council for the Yes. Doctor, Islamic Council, appearing for the respondent, Imam Standing Council, Revenue Customer, appearing for the respondents number 1 and 2. 1 and 2. So, heard Imam Standing Council, hearing concluded, we'll still do this matter again. Tell you the one. No, we are interfering. We'll give you time. You do the matter. We're interfering. I can't go beyond technical. No appeal in legal. That is in the facts of that. 53.
In any case, let's see. In any case, we find that if you have followed something that will be taken care by directing the Department of Proceeding to be completed within
When were you placed on the system?
31/2024.
completed within its period, but subsequent of that number one is completed within. In that case, it is. Okay, go with the people that
See, here the petitioner, the appellant had not participated. Here, everything is over long back and you are sitting over it.
one of the two was that the practice was even within.
Forget the charting, forget everything. Here the fact is that you were sitting over the matter, that which of course the department proceeding was concluded, which was given, he submitted in 2024. And you take 6-7 months to pass it on. That is.
We read it from the. That's.
No, that I'm telling you.
All right.
I gave you a chance last time so that you can pass the order. If you have not passed, I can't. We'll follow the.
Okay.
20? Yes, yeah, sir.
Only what witness has left for a reference. Only one witness has left for a reference.
Fine, you examine him as per your convenience.
2 months.
2 months, you reinstate him, whatever you do. Suspension gone. Reinstate him wherever you want. Within the state, outside the state, wherever you want, do it. And the charges against him are not very serious. No, may not entail a punishment of dismissal. May not, maybe also. But I am satisfied that the order and your statements in your affidavit, it's very clear. No, we are disposing. I have a decision. And that is with, that was, I did not have that decision of the division bench when I got the order. So division bench is very clear.
There are 7. No doubt, correct, but authority have not been included and or past and explicitly order. For the objection of the period of suspension of the petitioner within 90 days from the date of the issuance of the order dated 19. However, it is also
really true that on the one proposal which is called shall, a memorandum of judgment was served after the petitioner has. Don't see, here in this case,
I'm sorry, this final para 9, I'm not able to. This is contrary to the decisions of the government and the other parties. They're not, unfortunately, not the coordinate bench when this order was possible. We'll listen.
what's it, extended on to 15 days. No, do it.
You can't.
I.
There is another matter. 6 months, it was not.
And I have an record here in this case, what review was made.
Review was made after 90 days.
Was it 90, within 90 days?
No,
Charge sheet submitted, no.
the law is within, when you submit the charge sheet, you will have to
We
have.
have a memorandum also. We have a memorandum, page 115. In my affidavit. Paragraph 4. Paragraph 4 of that memorandum. It is stated 6 months. Review required 6. 6.
This is wrong. This is contrary to the decision in this and upheld by this court.
But attempt was made.
Fine. We are not interfering, we are not coming in way of imposition of any penalty.
That's too much, but verdict suspension. Few days is required, already not say, out of 2 witnesses, one already examined. And only 1 witnesses has left. And therefore.
Okay, I am. Hearing.
I have already annexed all these FAR already 5 of it.
We are not going into that. I'll only go by with their affidavit. Yes. So Monto, you are appearing for me. You have done your part. Yes. Fine. When? Huh? Ah. This decision was, you can't act as per your own sweet will. There is orders from this court.
That's it. Yeah. Sorry, make it fair.
3 weeks from the date of receipt of a certificate. Certified copy was given on 28/1/2025. And you are keeping the matter hanging till now. 6 months. 3 weeks, now it is 6 months. The college authorities have sent the proposal when?
I was not in chair.
You have read, you have said that. Then when you got it, you got in with touch with the DP? 20? May. So even after that 3 weeks.
Not this time, every other.
Huh?
This time, the volume, this, after, get the approval of secretary.
So you give me an undertaking that you will take the decision and place it before me on Tuesday. Why Tuesday? Thursday. Huh? Your name? Mr. P. P. Hazarika, Learned Counsel, appearing on behalf of Sir S.R. Rava, Learned Standing Counsel. the Bodoland, the council appearing for the respondent submits that he has been instructed that the respondent shall take the decision as required in the matter on or before. When is the correct? 23/7/2025, or on or before 25/7/2025, and the same would be placed before this court on the next date of this. Accordingly, raised it to this matter again on 29/7/2025, on which they the decision taken towards compliance of the directions involved in the matter shall be placed before this court.